Good morning, everyone, and welcome to our webinar looking at decision-making for public bodies. I am delighted that so many of you could join us on this lovely morning. My name is Catherine Allen, and I am the head of the Public Regulatory and Investigations team here in Mason Hayes and Curran. And in simple terms, what we do on a daily basis is advise public bodies about what, from a legal perspective, they can or cannot do and the procedures that they must follow. And that's what we're going to be talking about this morning. I am joined by this morning by Ailbhe O'Neill, and more on Ailbhe in a moment. Just to say, there will be some time at the end of our session this morning for some Q&A. You will see a Q&A function on your screen. So please enter your questions as we go along, and we will try to answer as many as possible at the end of the seminar. And you'll see a little timetable on your screen there at the moment. Now, just a word on Ailbhe O'Neill, who I'm very grateful for joining us this morning. Ailbhe is an Usher Assistant Professor of Law in Trinity College Dublin. She's also a very experienced junior counsel in the area of public and regulatory law. She advises on a huge range of legislation, and she was appointed, for example, as legal advisor to the Commission of Investigation into the causes of the banking crisis in 2011. She's also a co-author of Media Law in Ireland, which is now in its second edition. And we work regularly with Ailbhe, and I can't speak highly enough of the clarity and speed with which she delivers advice. And I want you all to have the benefit of hearing as much as possible from Ailbhe this morning. So you'll see we've allowed for that in the timetable, and I'm going to keep my own remarks on the topic relatively brief. However, as a starting point, I do want to set the scene a little and give you a flavour of some of the questions that come up time and time again for public bodies in a decision-making context. And very often the questions that come up can seem quite diverse and unrelated. And I've given a couple of examples there on the screen. What is evidence in regulatory procedures? And what is the extent of the duty to give reasons for decisions? I know that Ailbhe has some other examples in her presentation, things like, when is there a right to make submissions? When do I have to allow for an oral hearing? When do I have to allow for legal representation? And at face value, they all seem very different, very diverse, but there is a starting point for all of this. Why are we worried about these questions at all? And leaving aside, of course, the natural wish as a public body decision maker to do one's job properly, there is, of course, a more mundane reason, which is to try to avoid judicial review proceedings in relation to your decisions. So maybe let's speak for a minute about judicial review, as I think that gives us a backdrop against which we can consider all of these questions. And I've put on the slide the main grounds for judicial review. Now, before anyone gets onto the chat function and points out that I've left out some, I do know that, but I think it's helpful when talking about this area to try and have at least some categories or groups in our head that we can talk around, because it helps us then go back when we're looking at those questions that we mentioned before and trying to answer them. So you can, in the main, group grounds of judicial review into jurisdictional error or ultra vires, failure to follow fair procedures, and irrationality or unreasonableness. Now, today we're not really going to talk about the first category, the jurisdictional error ultra vires point, but Ailbhe's presentation will touch to some extent on the fair procedures issue. And I just want to talk a little bit around the irrationality or unreasonableness ground, because that feeds into answering the questions of what is evidence in regulatory procedures and what is the duty to give reasons for decisions. So I've popped up on the screen there some of the case law in this area. I'm not going to go through it in detail because much of it will be familiar to you, and if it isn't, the citations are there so you can take a look at it, the cases in your own time after the session. But just to give you the sequence of events, much of the discussion around irrationality or unreasonableness derived originally from a 1948 English law decision called Associated Provincial Picture Houses Limited and Wednesbury Corporation. And that developed into, the decision in that case developed what are known as the Wednesbury principles. And those became incorporated clearly into Irish law in the case of the State Keegan against Stardust Compensation Tribunal. And in that particular case, the court said that the test of unreasonableness or irrationality in judicial review lies in considering in whether the impugned decision plainly and unambiguously flies in the face of fundamental reason and common sense. And if it does, then the decision maker should be held to have acted ultra vires, and the decision maker must not flagrantly reject or disregard fundamental reason or common sense in coming to his decision. And that test was further refined in O'Keefe and on Board Planola. Again, most of you will be familiar with that. And in that particular case, the court held that the court cannot interfere with the decision of an administrative decision-making authority merely on the grounds that on the facts as found, it would have raised different inferences or conclusions, or it is satisfied that the case against the decision made by the authority was much stronger than the case for it. And in summary, the Chief Justice said that in order for the court to be satisfied that the decision maker was acting irrationally, it would be required that it had before it no relevant material on which to support its decision. And finally, in Meadows and the Minister for Justice, the court described its role in reviewing the rationality or otherwise of the decision. It remained axiomatic that it is not for the court to step into the shoes of the decision maker and decide on the merits of the decision, but rather whether the decision falls foul of the principles of law according to which the decision should be taken. So you can see from that decision makers are given quite a degree of latitude by the courts, and they only impose a finding of unreasonableness where there was no relevant material offering a basis for the decision. So you might well then ask, flowing from that, how do I show that my decision is reasonable and objectively rational? And the way to do that is to demonstrate that there is sufficient evidence before you on which to base your decision, so that your decision is not one made arbitrarily or on the basis of personal feelings, but you can show that you've looked at the available evidence and information and reached a considered view in the light of your powers and duties. And it doesn't matter if another person looking at the same material might have reached another decision. What matters is that the decision maker can show objectively to have taken the material into account and reached its own conclusion based on the evidence. So that brings us back to the question of, well, what is evidence then in regulatory procedures, which is one of the questions we started with. And that has been considered in various different cases. There's an interesting one I'd like to mention, which is the Ashford Castle case, which is mentioned on the screen at the moment. And there's a quote from that, and just bear with me as I have it on my other screen here, but I just want to give it to you. It says, the court said, the tasks with which administrative bodies are given under statute vary significantly. At one end of the spectrum are issues which involve the same sort of mixed questions of law and fact with which the courts are frequently faced. A person may, for example, be entitled to a social welfare benefit, provided that a certain set of facts, as specified by statute, are found to exist. At the other end of the spectrum, expert bodies may be required to bring to bear upon a situation a great deal of their own expertise in relation to matters which involve the exercise of an expert judgment. Bodies charged with, for example, roles in the planning process are required to exercise a judgment as to what might be the proper planning and development of an area. Questions of expert opinion may well be in dispute and may be resolved in a manner similar to the way in which similar issues would be resolved in the courts by hearing and, if necessary, testing competing expert evidence. However, above and beyond the resolution of any such issue of expert fact, the authority concerned will also have to bring to bear its own expertise on what is the proper planning and development of the area. Now, I want to just touch on expert witnesses here for a moment, particularly as that quote referred to expert witnesses. So in my view, it's increasingly common for public sector, public body decisions to be based in one way or another on some form of expert evidence, particularly as more and more specialist areas and niche areas are being developed. And very often the decision makers may not have expertise in that particular niche area or specific area in question. So they will turn to experts either internally or externally to provide evidence upon which to base their decision, and therefore to show that their decision is not irrational or unreasonable. And that, of course, is an excellent idea in principle, but there are a lot of considerations that you need to take into account before you put that idea into operation in practice. One of the first things to think about is who do you select as your expert witness. So for the most part, witnesses can, of course, only give evidence as to fact. The only reason that an expert can give evidence in relation to an opinion is because that person is considered to have expertise in the area in question. Clearly, if it's later discovered that that particular expert does not, in fact, have expertise in the area in question, the opinion that that person gave in relation to the area is worth little or nothing. And if you have based your decision on the basis of an expert, a so-called expert, which later proves not to be an expert, then clearly you have a difficulty. That doesn't arise too often in practice, but it is important to state it at the outset. What I do see happening more often as an issue in practice is the issues around briefing the expert concerned and precisely the questions upon which you're asking an expert to give an opinion. Because the greatest difficulty often arises in relation to expert reports when they come back to the person who has commissioned the report, and the report contains a lot of material that you didn't expect to be there and creates huge difficulty in relying upon the report or the opinion, or indeed even circulating the report. And it may, for example, contain statements which are perhaps clearly biased or on evidence that was not provided to the expert, or it may contain defamatory statements. It may contain a lot of different issues which create a problem for you in order to rely on it as a decision maker. The consequence of that is it's not easy to dispense with experts once you have commissioned them and received a report, even a draft report from them, because it looks like expert shopping, essentially. And if you don't receive an opinion from an expert that you like, it looks like you've gone to someone else to find an opinion that does suit the decision you want to reach. Of course, that's not what you have actually done. There may be a really genuine problem with the opinion, the written opinion that you've received from the expert. But once you've received that opinion, it's very difficult to do something about it, and it can leave you in a very awkward position. It's difficult to fix after the event. So the best way to deal with it is to ensure that when you are instructing an expert, that you are very clear upon the basis upon which you're briefing them and the questions upon which you're seeking their opinion. It doesn't cure all issues, but it certainly helps a lot to be very clear at the outset with the expert what you're asking them to do. If you need to instruct experts a lot, it's definitely worthwhile putting together a template pack of briefing documents so that you're providing the experts with the same set of questions or the same basic set of material on every occasion. And of course, if you're getting problematic reports back from experts, problematic not in the sense that they don't support your decision or they're not helpful towards your decision making, but that they contain a lot of other material in there that creates issues, you might need to look at your briefing materials and see if they can be refined so that these issues are certainly lessened, if not removed entirely. The expert also needs to understand and be aware that he or she could be subject to cross-examination on his or her opinion should the matter come up in court or some other adversarial forum down the line, and needs to be able to cope with that prospect of cross-examination. Moving on from the question of expert opinion, just briefly to touch on the type of things that the courts have decided are irrelevant considerations. And they're things like the need to get business finished quickly, assumptions not based on evidence, personal experiences or views of a different situation, and indeed dislike for the person affected by the decision or what they represent. All seems completely obvious when you see them written down on a slide, but not necessarily, given that there have been a number of cases in relation to issues such as these. So to follow on from our starting point, you need evidence upon which to base your decisions in order to be able to show that they're not irrational or unreasonable, and that you've taken all material considerations into account and excluded immaterial ones. Then moving on to the duty to give reasons. Again, given the time available, I'm not going to go through the fairly extensive case law around the duty to give reasons. I've set them out on some of the primary ones on the screen. There are just a practical point that I want to make around the duty to give reasons, and it particularly arises from the second case on the screen, the Durland Construction Limited case. So I think most decision-making bodies are perfectly well aware that they must give reasons for their decisions. That's not really in dispute or in doubt. What seems to actually cause more difficulty is the extensive reasons for decisions that some public bodies feel they need to give. And sometimes it's a little bit like the expert opinions. It's the extraneous commentary or views expressed in a decision which actually cause the greatest problem, rather than some of the core issues which were for decision. And it's a little bit like that famous quote, "I wrote you a long letter because I didn't have time to write you a short one." Sometimes the short, concise, precise decisions take longer to write, but they're safer in the long run because you don't get tripped up by some throwaway remark or comment, which you thought was helpful at the time, and maybe in guiding the person who was going to be the recipient of the decision, but actually creates more trouble in the long run. And this is why the Durland case is helpful, because it quotes from another case, which is delivered in England and Wales, which is referenced in the decision. But again, if you'll just allow me to quote from it, it says, "The reasons for a decision must be intelligible and they must be adequate. They must enable the reader to understand why the matter was decided as it was and what conclusions were reached on the principal important controversial issues, disclosing how any issue of law or fact was resolved." Now, I'm skipping down a little bit because this is the key point. Reasons need refer only to the main issues in dispute, not to every material consideration. They should enable disappointed developers, this was a planning case, to assess their prospects of obtaining some alternative development permission, or as the case may be, their unsuccessful opponents to understand how the policy or approach underlying the grant of permission may impact upon future such applications. Decision letters must be read in a straightforward manner, recognising that they are addressed to parties well aware of the issues involved and arguments advanced. A reasons challenge will only succeed if the party aggrieved can satisfy the court that he is genuinely being substantially prejudiced by the failure to provide an adequately reasoned decision. So I think that's very helpful, that lengthy discursive judgments, as you might see from a court, are not required in, generally speaking, in a public sector decision-making context. The reasons should be particular to the decision. They shouldn't be stock responses, but they don't have to be very, very extensive either. Now, just before we conclude and I hand over to Ailbhe, I just want to make a final point around information disclosure obligations. And I suppose this really goes back to the point around expert witnesses in particular, but also generally in relation to any materials that might be on your files. There is little point in having a carefully crafted, reasoned decision which sets out why a particular decision was reached and the grounds for it, if your underlying file doesn't support that decision which was reached. And in fact, if you had perhaps, as I say, one of those unhelpful draft expert opinions on your file, for instance, it's pretty unlikely that that is going to remain buried for any length of time. There are, of course, discovery options available, but even before going to discovery, I don't need to remind everyone here that you're subject to the Freedom of Information Act. Very many organisations also have obligations under the European Community's access to information on the environment regulations. And of course, I don't need to tell anyone here about the GDPR and Data Protection Act 2018. And we see those pieces of legislation routinely used to obtain information from public sector files and subsequently used in litigation in relation to decisions reached by public bodies. So it's just important to be conscious of your file when you're reaching those all-important decisions. So that's all from me for now. I'd like to hand over to Ailbhe, and thank you very much.
Thank you, Catherine. Good morning, everybody. Hopefully everybody can hear me. I'm sure Mason Hayes will let me know if you can't. So what I'd like to address you on today is the issue of participation in decision-making. And there's three sort of key issues I want to look at that I think come up quite regularly in practice. One is the entitlement of people who are the subject of or affected by a decision-making process to make submissions or representations. And then I want to look at the potential for a right to an oral hearing. And then lastly, I want to look very briefly at the potential rights to legal representation. But before I look at any of that, I would just like to note that it's always worth going back to first principles, I think, when we're looking at fair procedures. And of course, the starting point is that wherever the Oireachtas provides for a procedure, it's presumed that it's required to conform to the requirements of constitutional justice. And that's in the well-known case of East Donegal that I'm sure you're all familiar with. Another point that's also worth noting, and it was reiterated really strongly by the Supreme Court in the Delway case, and that is that there is an almost absolute duty to abide by fair procedures, but the content of that duty is highly context dependent. And of course, the devil is in the detail. And when as a decision maker, you're trying to figure out what is required, it's that detail that you need to be familiar with. Before I start looking at the types of decision-making processes that have been considered by the courts, I think it's also worth noting that there's a recognition that this type of requirement, or whatever type of requirement applies in terms of participation, is burdensome, but the courts have firmly said that it's unavoidable. And there's a quote there from Mr. Justice McMahon in the Can case, where he, I think with perhaps some sympathy for the plight of the decision maker in a public body, notes that to those involved in administration, adherence to fair procedure standards may appear cumbersome, irritating, and even irksome on some occasions. Undoubtedly, the necessary adherence may slow down the administrators and may not be conducive to efficiency, but that is the way it is. The battle between fair procedures and efficiency has long since been fought, and fair procedures have won out. And I think perhaps when faced with yet another round of submissions or yet another round of representations, it's worth reflecting on that. And because I think it's always important when you're in the middle of a decision-making process to imagine yourself 6 months or maybe even a year down the line, sitting before a High Court judge and having to justify why you didn't allow somebody to make further representations, or why it was necessary to sort of cut the process short. Because I think those decisions, while they are usually made for the best of reasons, sometimes when you get further away from them, it becomes more difficult, I think, to justify them. So it's always worth just stepping back objectively and saying, somebody coming to this fresh, what view would they take of this, the fairness of this particular procedure? When I'm talking about decision making, I'm conscious that there's a range of public bodies attending this webinar, and you'll have all different types of procedures and processes in place. But one thing just to be conscious of is that there has been, I suppose, an increasing refinement of the understanding of how the courts approach fair procedures in what I'm going to call multi-stage decision making. And that's kind of evolved over a number of years. And the Supreme Court has given, I think, helpful guidance on it in the last sort of 5 years. And I don't want to go through all the older cases in detail with you, because they're superseded to an extent, I think, by the two more recent authorities that I want to look at in a bit more detail. But just to note that there were older authorities like Ingle and Moran that suggested that you couldn't correct flaws by having a sort of a second stage in a procedure, by having an appeal. Then there was a case called Duffy, which suggested that if a decision doesn't take immediate effect, and then you later have the opportunity to make submissions, that later opportunity might suffice to meet the obligation imposed to accept submissions under fair procedures. There are older cases then that develop that even a bit further, and or later case, I should say, like Gamble and McNamee. And those cases suggested that if you have a two-stage process and the first decision doesn't take effect, or takes effect only after the effluxion of time, or after a decision not to challenge it or not to enter into the second stage, again, that right that exists at the second stage can suffice. And then Scariff and Taylor, if you have a full de novo hearing, that may cure defects at the preliminary investigation stage. All of those authorities involved, I suppose, an accretion of detail and a gloss on the overriding principle, which is that procedures have to be fair. But I think it's fair to say they didn't really provide a huge amount of guidance to decision makers, and they were all quite context specific. So the Supreme Court sought to kind of clarify the law in this area in two authorities, one of which I think you'll all be familiar with and the other of which you may not. The first case is the Craden fishing case. And this was a case that arose from the vexed area of the law of fisheries licenses, which is a rather complex area of the law if you haven't had the pleasure of dealing with it. But in this case, a license holder was notified of a proposed assignment of kind of penalty points on your fisheries license. And they were told that they were going to be given these points or have these points imposed. And they were also told in the same correspondence that they were entitled to appeal within 21 days to an independent appeals officer. But if they didn't appeal, or if they did and they were unsuccessful, the points would then be applied to their fishing license. But there was no opportunity to make any representations before that first stage of the process. And the appeal itself was quite limited. And that was challenged, and the challenge made its way up to the Supreme Court. And in the Supreme Court, Mr. Justice O'Donnell took the opportunity to sort of try and put an overarching set of principles in place, looking at all of those older cases and some other cases as well. And the starting point for him was to note and to really signal, I think, both to lower courts and to decision makers, that the courts have remained slow to require the full panoply of the requirements of procedural fairness at a preliminary stage in a process. And so he said, that all of the requirements of fair procedures that have been established in all of the case law, they don't necessarily apply to these sort of preliminary stages of decision making. In this case, however, looking at the fisheries licensing regime, what you had in effect was really a single decision-making process, because effectively somebody who had been the subject of the first stage of the process carried the onus of disproving the penalty points at the later stage of the process. And they never had any entitlement to make submissions before that first decision was made. And he found that that did not meet the requirements of fair procedures. Understandably, of perhaps a little bit frustratingly, his judgment says that really there's no bright line rule and it's context specific. So you have to look at the fairness of the procedure overall. The second signalling, I think, from the Supreme Court comes a number of years later in the Shatter and Gearan case. And I think this is the case pretty much everybody will have some passing familiarity with. The respondent in this case, as you probably know, had conducted a preliminary inquiry and had drawn up a report with a view to making recommendations about the establishment of a formal inquiry. And that formal inquiry, the O'Higgins Commission, subsequently did take place. But following the delivery of the report and a meeting with the Taoiseach, the applicant resigned his ministerial office. Later on, he was exonerated from criticism in the report that was ultimately delivered by the O'Higgins Commission. And Mr. Justice O'Donnell in the Supreme Court, in considering the fairness of the original stage of the reporting and the preliminary inquiry, noted that that recommendation by the respondent who had conducted this first stage of the process couldn't be seen as the final word in the process, reflecting on the reputation and good name of any person. And he pointed out that that process wasn't the only means of vindicating that reputation and good name. And that opportunity, according to the Supreme Court, arose at the commission stage, at the second stage. And that meant that there was an opportunity for the individual to vindicate his reputation. And in fact, as it turns out, he did so vindicate that reputation. That second stage of the process, the O'Higgins Commission, was bound, therefore, by all of the sort of fair procedures requirements. But the first stage was not necessarily so bound. There's another finding in the case in relation to the first stage of the decision-making process, but you don't need to concern yourself with that because it's not really relevant to what I'm dealing with today. What's also worth noting is that Mr. Justice O'Donnell in Shatter and Curran tried to give more guidance, I think, to decision makers about how to approach what's required at different stages. So he pointed out that where there are a number of related procedural steps, the fundamental question is whether the overall process is fair. And this case obviously involved somebody conducting a preliminary inquiry with a view to then making recommendations as to the establishment of a more formal inquiry. And that formal inquiry itself was to be conducted in accordance with fair procedures. And he said that in that type of situation, the first stage of the decision-making process of the investigation is not required to accord such procedures. And then he gives examples of the types of things that are not required at the first stage: legal representation, submission, cross-examination, or some process of submitting a draft report to interested parties and receiving comments thereon before delivery. He does go on to say that it's not to say that it's not a counsel of prudence to take steps to engage with all interested parties as fully as possible before making any conclusion in relation to them, not least with a view to strengthening any factual findings. A failure to do so may undermine the cogency and persuasiveness of the report as a matter of fact. Just to step back from that for a moment, and depending on the context in which you're making your decision or in which your procedure is taking place, it's really important then to think about, well, how would this be characterized as fitting into an overall procedure? Is this something that is just a recommendation leading to a later stage, and at that later stage those procedures will be available? Or is it something that's effectively going to impact somebody immediately in some way and therefore may require the full panoply of fair procedures? The other aspect, of course, of Shatter and Curran to note is that it was concerned with those principles that are at the core of the re Haughey jurisprudence, and that is one's right to a good name and the public pronouncement of findings which could impact on somebody's good name. So whenever you're operating in that type of sphere, I think there's a particular onus to take care in relation to the procedures that you adopt. When I'm looking at participation then in the rest of my presentation, I really want to focus on three particular areas. The first is the right to make submissions or to comment on drafts, and I've put those kind of together because I think they usually travel together. The second is the right to an oral hearing, and then the third is the right to legal representation during a process. And again, all of these are highly context specific, and you need to look at the impact stage and structure of the decision-making process that you're engaging in. But there's some low-hanging fruit, I think, for every decision maker in terms of abiding by fair procedures. And what I mean by that is there are things that you can do to make your decision making more robust that are not necessarily terribly resource intensive, both in terms of workload and also in terms of time. And I think the first of those is undoubtedly the decision to allow interested parties to make submissions. And I think that, you know, there are very few circumstances in which that's really not appropriate and in which it creates, you know, a disproportionate burden on resources. There can be complications, of course, in that, where, for example, parties have different positions and the potential for endless to and fro and rounds of submissions. But I think that can be dealt with quite easily by having very clear guidance on deadlines, mode, and circulation of any submissions, so that there is an endpoint to that process once you enter into it. And I think the same applies to commenting on drafts. So if you're involved in a decision-making process where you have maybe a draft report or draft findings, that it's appropriate to circulate, again, the typical report is a typical example is sort of the draft report that's circulated for comment to interested parties. Again, you know, the key is just to be really clear about what mode and deadline for input is part of your procedure. What happens then where there are challenges to facts or interpretation in a draft? And I think then you're under an onus to be particularly careful about how you address those. And it's no harm to maybe have built into your initial circulation some explanation of how that will be dealt with. And it's also very important to take an objective appraisal. You know, it's not unusual for people to, or for the subjects of decision making to suddenly, you know, come up with some argument they haven't made before, which can be incredibly frustrating if you've given them an opportunity at an earlier stage in the process. But it is very important to put that to one side and to ask yourself objectively, you know, is this a genuine issue that's arisen? And if it has, you may simply have to just reopen and recirculate, even if that does take a little bit more time. All of these decisions involve, I suppose, from a public decision-making point of view, a sort of a balancing between, on the one hand, the overarching objective, which is, of course, to come to the right decision, but even just beyond, sitting behind that, then there is also this, I suppose, necessity to consider the proportionality of the resources that have to go into it versus the risk that failure to do that is somehow going to impact on the quality of the decision and potentially land you in a judicial review. Just leaving aside submissions and commenting on drafts then and looking at oral hearings. I think it's always important to consider, you know, what's the function of an oral hearing? Like, what's the point of having one? And generally, they're there to resolve conflicts of fact or evidence through oral examination and usually through cross-examination. That doesn't mean that every time there's a conflict of fact, you have to have an oral hearing. And sometimes as a decision maker, you have the function of resolving a conflict of fact and coming to a conclusion on it. It may be possible to do that without, in many cases, having an oral hearing. If, however, there is going to be a sort of a lack of documentary material on which to base your decision, and one party is strongly looking for an oral hearing, you also have to consider, well, rather than simply wading into an oral hearing, do you actually have the powers and procedures you need to effectively conduct that hearing? Because an oral hearing that's conducted without those powers in reality isn't likely to add much to the quality of your decision, and in fact may trip you up in other ways. The requirement to have an oral hearing is, you know, relatively limited. And in Galvin and the Chief Appeals Officer, it was held that there are no hard and fast rules for, in that case, for when you have to have an oral hearing for the purpose of the dictates of fairness. In that particular case, it involved the entitlement of the applicant to a pension, and there was a dispute on the facts about whether the wages of the applicant exceeded the insurable limit. And it was found that because of the challenge to the accuracy of the record keeping in the case, that couldn't actually be determined without cross-examination. So in that particular case, an oral hearing was merited. And in that case, the court pointed out that you have to look at the circumstances pertaining, the nature of the inquiry being undertaken by the decision maker, the rules under which the decision maker is acting, and the subject matter with which he is dealing. But in that particular case, it was found that there was a necessity to have an oral hearing. It's worth pointing out that in that case, of course, there was something quite significant at stake for the individual when looking at the overall context. So one's entitlement to a pension, which is obviously a significant impact on the individual, and that, I think, plays a part or had a part to play in the decision in that case. As a counterpoint to that, and there's another decision that I just thought I'd look at with you briefly, and that's the Martin decision. And this was a decision of the Data Protection Commissioner that was the subject of judicial review proceedings. And in that decision, the underlying facts were that the applicant alleged that a director had verbally disclosed information to his own father relating to outstanding loans that he had with the credit union. And both the credit union and the director denied that any such verbal disclosure had occurred. So it was litigated under the guise, I suppose, of a data protection issue. And the Data Protection Commissioner found that it wasn't possible to form a definitive opinion on a complaint about verbal disclosure without any documentary evidence. The complainant then requested an oral hearing before the Data Protection Commissioner, and the Data Protection Commissioner declined to grant that hearing. And then in the meantime issued a formal decision that there was no evidence that any verbal disclosure containing the applicant's personal data was made by the credit union or by the director. That was then the subject of judicial review proceedings. And Mr. Justice Houghton in the High Court found that EU data protection law didn't require member states to give bodies such as the DPC the power to conduct oral hearings. So there was no basis for that requirement as a matter of EU law. And the Irish legislation that implemented it also didn't give the DPC the power to conduct an oral hearing. And he pointed out that the power to have an oral hearing is very significant and that the court should be slow to find that a regulator enjoyed such a power. Here, there was no power or powers to take evidence under oath. There was no general power to compel the discovery of records. There was no power to summon a person to attend a hearing, and there was no power to provide for cross-examination. So in light of all of that, he found that that there was no basis for the challenge in this judicial review to the decision of the Data Protection Commissioner not to grant an oral hearing. A couple of health warnings, I think, about the Martin decision. It is quite context specific. Also, Mr. Justice Houghton, in his judgment, did note that the applicant in the case had the option of a full appeal to the Circuit Court and had chosen not to exercise that option. And he pointed out that if that had been done in the Circuit Court, the credit union could have been joined as a notice party, and the dispute then could have been clarified after a full oral hearing in court, where all of those procedures would have been available. And he found that the factual dispute about the alleged disclosure could have been resolved if that option had been taken. So it's important to note that there was, I suppose, an alternative route available in that particular context. And again, this goes back to just understanding where your own stage in the process fits in terms of the overall structure of the decision that you're making. As a counterpoint to that, then, I've included on the slides the Financial Services Ombudsman case in J&E Davy. It's a Supreme Court case in 2010, again involving a credit union, coincidentally. And here, a credit union made a complaint against Davy to the Ombudsman about the investment by the credit union in 3 perpetual bonds, which had declined in market value. And the Deputy Ombudsman issued a report upholding the complaint of the credit union and making certain directions. Davy then made further submissions, and so did the credit union, on that report. And then the Ombudsman finally issued a final decision. And that was challenged by Davy actually in a number of different streams of litigation, including this judicial review, and on a number of grounds. But one of the grounds was the refusal by the Ombudsman to hold an oral hearing. And the Ombudsman, in defending the decision not to hold an oral hearing, relied in part on 2 provisions the Central Bank Acts, and those 2 provisions are on the slide. The first provision noted that the objects of this part, being the part that sets up the FSO office, was to enable such complaints to be dealt with in an informal and expeditious manner. And then the second provision pointed out that the FSO is entitled to perform the functions imposed and exercise the powers conferred by the Act, free from interference by any other person. And it also goes on to say that when dealing with a particular complaint, the FSO is required to act in an informal manner and according to equity, good conscience, and the substantial merits of the complaint without regard to technicality or legal form. So the FSO relied on those provisions to defend a decision not to allow an oral hearing. And the High Court recognised those statutory provisions and said while they were relevant considerations that the FSO could take into account, the FSO in this case had breached fair procedures in refusing an oral hearing, and the Supreme Court agreed with that analysis on appeal. And the reason for that is that there was a dispute here as to material facts which required oral evidence and cross-examination for a just determination to be made. It's worth noting that in this case, there was a further dimension which I think impacted, apart from the very big stakes that were at play. And that's also that the FSO had refused to provide access to documentation that had been provided by the credit union to the applicant. And that included statements from a number of persons within the credit union. And Davy had argued quite strongly that they needed to cross-examine on those statements, and also that they should have been provided with them. So I think that certainly had an impact on the overall analysis of the fairness of the procedure. Nonetheless, it is, I think, salutary to note that, you know, here you have a piece of legislation that is avowedly setting up a process that should be informal and expeditious, and there are similar formulations in a number of other statutory contexts you'll have come across. And nonetheless, the court says that, you know, a full oral hearing was in fact required. Moving on then, and just looking very briefly at legal representation as sort of the third aspect of participation. It is something that arises more often in a disciplinary or investigatory context. And the factors which will inform the issue will be the nature of the decision-making body, the potential consequences for an individual if an adverse decision is made, and the factual complexity of the issues raised, and whether any points of law are likely to arise. And I think it's fair to say that there has been a clarification of the law. It's about 2 years ago, almost to the day, in a case called McKelvey and Irish Rail. And that was a case where an inspector of Éireann Road Éireann, who was part of this procedure where he had fuel cards to facilitate the refueling of company vehicles and machinery, was found ultimately to have been involved in theft. So there was a concern raised initially about expenditure and a preliminary investigation. And as part of that preliminary investigation, he was interviewed, and he was accompanied by a trade union representative to that interview. And then after that, he was suspended while disciplinary proceedings were taken. And he then asked to bring a solicitor and counsel to the hearings on the basis of the alleged complexity of the issues. The Éireann Road Éireann policy clearly precluded that, and so that request was denied. And then he challenged that in the High Court and Court of Appeal. And he brought injunction proceedings to restrain the disciplinary process, saying that to allow it to go ahead without legal representation would breach his constitutional rights to natural justice. And he was granted that injunction by the High Court. That decision was appealed by the company, and the Court of Appeal discharged the injunction allowing the appeal. What's interesting about this case, and I think it can sometimes be frustrating when you're trying to apply these principles in practice, is that actually both the High Court and the Court of Appeal applied the same criteria, but came to different conclusions. And for reasons of time, I'm not going to go into those criteria in detail, but essentially they relied on criteria that had been approved by the Supreme Court in a case called Burns. And Burns approved these Tarrant criteria, which I've set out on the slide here. And these criteria were applied to completely different effect by both the High Court and the Court of Appeal. Ultimately, the case went to the Supreme Court, and McKelvey in the Supreme Court was dealt with in the following way. The Supreme Court said that the key issue is whether the disciplinary proceedings could continue without legal representation, and whether that would amount to unfair proceedings. And they said that the criteria that had been applied by the High Court and the Court of Appeal were not factors which had to be separately established, but they were just part of the overall picture. So they and other appropriate factors would go into an overall evaluation made in the context of reaching an assessment as to whether legal representation is necessary for the process to be fair. And the key question posed by the Chief Justice in McKelvey is whether legal representation is necessary rather than merely potentially being of some advantage. And he took the view, and the Supreme Court took the view, that the evidence might have been complicated about the fuel cards and the expenditure and how this matter came to light, but the allegations themselves were fairly straightforward. They also pointed out that Éireann Road Éireann had various well-established procedures that a trade union official would be well familiar with, and that they were entitled to attend with Mr. McKelvey. And they said nothing in this case would be beyond the competence of an experienced trade union official. So the presence of a trade union official would adequately ensure a fair process in this case. One key issue, and I think it's really the key difference between how the different courts approached the McKelvey situation, was that Mr. Justice Murphy in the High Court had emphasised the nature of the allegation, very serious allegation of theft, and the potential impact of the decision on Mr. McKelvey, which ultimately could involve his dismissal. But both the Court of Appeal and the Supreme Court took the view that those issues alone couldn't result in the requirement for legal representation in a disciplinary hearing, and that a disciplinary hearing could really only require legal representation in exceptional circumstances. Just to note that, and then just to finish off, that in multi-stage decision-making, you have to be aware of how each stage of the process might be analysed and under the overall approach under Curran and Curran, which is effectively that there has to be a fair procedure overall. And you have to look at what stage of the procedure you're at when making your decision and what is coming down the line in terms of later phases of the decision-making. When it comes to participation, then I think the key to making the right to make submissions and representations is key. And I think it's very difficult to shut people out from that process, which isn't to say that you can't manage it and have a reasonable timeline for it. Secondly, the right to an oral hearing, I think, is quite limited. And really, if you're asked, to provide an oral hearing, you have to look at whether that request is really going to add anything to the decision making, and also whether you really have the powers and procedures to allow it to happen. And then thirdly, just to note that in the Supreme Court decision in McKelvey, I think it's a very strong signal that legal representation is not going to be the norm in disciplinary proceedings. And of course, there's exceptions to that in the more highly regulated professions, which have their own procedures. But if you're in a situation that falls outside of that, the right to legal representation is something that is really quite limited, according to the Supreme Court in McKelvey. Thank you very much. And apologies, I think I've run over time.
Not at all, Ailbhe. That was really interesting. Thank you very much. We have a short time now for Q&A, and just to say, in response to one of the questions raised earlier, yes, the slides will be circulated and the webinar has also been recorded, and that will be available for you to view again later on or to share as you wish. So just turning then to the questions, if I may, and they're on my screen here, so apologies if I'm clicking away here on the camera. The first question, I think, Ailbhe, if I could ask you to take that, please. If there are submissions, should those be shared with all parties?
I think that depends on the context, because obviously it depends what's in those submissions. So, and it depends on the type of decision you're making. But I think in general, yeah, I think they should be, because apart from anything else, it's going to make your decision making difficult if you have material that's forming part of your decision that other parties who are affected are unaware of. And that's one of the key sort of pitfalls, I think, in decision making. But it really depends on the context. If you're at a very early sort of scoping stage of a procedure, that may not be required. But if you're at a later stage of a procedure, yes, I think it's good practice to make them available, even though the danger is, as you'll know, it's going to prompt further submissions. But again, it's about structuring that from the beginning.
Okay, thanks, Ailbhe. I think the next one is probably a little bit for both of us to answer. So it's, if there's an implied right to reasons and to fair procedures, what impact do particular expressed requirements in statute have? Do they complement or limit the rights and obligations of the parties? And I suppose if I were just to start on that, any statutory requirements for your process should of course be adhered to in the first instance. It is assumed that those that legislation is drafted with the constitutional right to fair procedures behind them, and certainly should be interpreted in that way. Ailbhe, would you have a view on that?
Yeah, I mean, I think that, again, it's difficult to answer in the abstract without a concrete example, but I think the overall requirement of fair procedures is paramount. And I don't think that to put it this way, if a statutory procedure itself is potentially unfair, it puts you in a difficult position as the decision maker, because you have to act obviously according to the procedures you're given. And that actually happens quite a lot in practice, where you have a statute which sets out a procedure which maybe doesn't quite contain the level of procedural protection that it might. And I think that while there can be a danger in trying to manufacture your own procedures, I think that as a rule of thumb, it's the constitutional requirements of fair procedures that are paramount. So it may be that you have to add something additional into your process that isn't set out in the statute to keep it fair. But again, that can be difficult to do. And I think if you reach that point, you're probably picking up the phone and ringing Catherine and asking her for her advice on the context.
Thanks, Ailbhe. An interesting question there on representation. Any views on rights of witnesses to be legally represented before a regulatory body?
Yeah, this comes up all the time in practice. And I think that the general rule is no, you're not entitled to representation as a witness unless you yourself have some particular, something in particular at stake. But if you're literally just coming along and giving some evidence, then I think you're generally not entitled to legal representation. And there can be exceptions to that, but that the general rule of thumb is no.
Yeah, that is definitely one that comes up from time to time. A specific question there in McKelvey, and I think this is maybe more of a comment than a question, but in McKelvey, the allegations may have been simple, but surely the rights and obligations of the accused and the procedure was legally complex. I don't know if you have any view on that, Ailbhe. That's a little more in the way of a comment, I think.
Well, I don't have a view on it. I mean, I think the key takeaway from McKelvey is that the Supreme Court is just signalling very strongly that legal representation is not going to be available for the asking in those types of proceedings. And actually, I mean, I think you could take the view that the background to McKelvey is quite complex, but the Supreme Court took the view that the allegations are fairly clear. I think it is a bit different where you have a trade union official accompanying you as well, because the assumption is that they're, well, and in fact, having appeared in proceedings with trade union officials, I can say, they're usually very capable of representing their clients. And I think that undoubtedly influenced the decision in that case.
Okay, great. And I think we have one very complicated question in the text box. It might be a little bit too detailed maybe for this session this morning, but if whoever posed the question would like to get in touch later on, I'm sure we'd be able to help you with that one. So that seems to deal with all of our questions this morning. All it remains for me to do is to thank Ailbhe very much for attending this morning. It was a really interesting and helpful presentation, and also to thank you all for attending. We really appreciate your time. There will be a short feedback survey after the session. When you close out of it, we'd be delighted if you would complete that. And otherwise, just to say thank you again, and that brings our webinar to a close. Thank you. Bye-bye.